Welcome. Thanks for joining us for today's webinar, Beyond the Talking Points, Part 2, Top Solutions for Florida's Families. I'm Roy Miller, co-founder and president of the Children's Campaign. Our colleagues refer to us as Florida's oldest and most respected independent and nonpartisan child advocacy organization. We appreciate the designation. Every 2 years, the Children's Campaign initiates a statewide effort to raise the visibility of children's issues when publicly aware citizens are more likely to pay attention. Our effort shines the spotlight on children when action committees and candidates are spending hundreds of millions of dollars to make themselves known. It's been said by many that children can't vote and therefore are too easy to be overlooked. We accept the challenge to ensure that babies and children aren't kissed on the campaign trail and then forgotten after Election Day. For 26 years, one thing that most every Floridian agrees with the Children's Campaign is children are our future. Our success tomorrow and in the days and years that follow largely depend on the actions we take to ensure their safety and well-being today. That's why this webinar is so important, and we're thrilled you're joining us. The agenda for today's webinar. First, we'll learn more about continuing lack of equity in the treatment of girls and young women in Florida, including the staggering number whose basic needs are not met, leading to arrest, imprisonment, and technical violations of probation and other nonviolent and non-serious offenses. Next, we'll cover the latest trends in the child welfare system, including the alarming rise in the number of children removed from their homes. That increase impacts caseloads and is felt throughout the foster care system. How has Florida responded? Our third presentation will provide insights on the practice of direct file. That's a term that really means the laws in Florida allow children to be tried as adults. You may be surprised at the number, the inconsistency across the state, and the outcomes. I'll introduce our highly respected speakers as we go along. To the many candidates who have joined this call, thank you for your courage. Thank you for caring about children. Thanks for your interest in pursuing public office. We know it's a hard, hard journey. We wish you well. I'd also like to thank our key partners for our Made in Florida Civic Engagement campaign, who have made this webinar possible. We can't do our work without our partners, and we appreciate every one of them. A few housekeeping details. As a courtesy to others, your microphone has been muted to prevent background noises from interfering. To pose a question to one of our experts, please type it using the chat function. I will see it. It is our plan to answer as many questions as we can after our experts have finished presenting. A recording of the webinar will post to our website no later than Monday. An email with a link will be sent to all who registered. And now, without further ado, I'd like to introduce Dr. Lawanda Rabora.
Good morning, everyone, and thank you, Children's Campaign, Roy Miller, and the apprentices for the work that you've done to bring this webinar together. For upwards to 20 years, the Justice for Girls work in Florida has been led by the Children's Campaign in partnership with the Dolores Barr-Weaver Policy Center. Together, our organizations have envisioned and brought forth and passed fundamental legislation and historic reforms for girls and young women impacted by the justice system. But despite the documented success in reversing some of the negative trends and policies and practices, justice-involved girls continue to face pervasive inequality, service failures, and multiple barriers that derail their future. Next slide, please. The recent headlines in Florida's newspapers indicate that we are at a critical juncture in preserving the progress that's been made in the justice system for girls. Just in the last few months, We've all seen the headlines of abusive girls in detention centers, which tell a harrowing story. Guard raped girl in detention, Orlando Sentinel. A girl hanged herself in the detention center, Bradenton Herald. Lawsuit filed for girl abused in the Duval Detention Center, Florida Times-Union. These headlines are an urgent call to action. Next slide. In Florida, nearly 1 in 3 youth referred to the Department of Juvenile Justice is a girl. In spite of the reductions that we've seen in the number of girls arrested and incarcerated in Florida, as well as the decrease in all youth coming into the system, horrific disparities continue for girls and young women. Next slide. Girls are entering the juvenile justice system for far less serious offenses than boys. In fact, 64% of girls versus 42% of boys are entering the system for a less serious offense, for misdemeanors and other offenses. Next slide. This also is reflected in the incarceration rates for girls, where we are seeing girls incarcerated for less serious offenses. 50% of girls versus 23% of boys are incarcerated for offenses such as misdemeanors, violations of probation, or other offenses. This is more than double the rate for boys. 30% of girls versus 10% of boys were incarcerated for a non-law violation of probation as their most serious offense at the time of disposition. So 1 out of 3 girls are incarcerated for a non-law violation of probation as their most serious offense. So probation is the time where youth are placed on community supervision and they're supervised by a juvenile probation officer through a court order. If the conditions of probation or the post-commitment probation programs are violated, the Department of Juvenile Justice or the state attorney may bring a child before the court on a petition alleging a violation of the program or a violation of their probation. If a child who violates the conditions of probation or post-commitment is brought before the court, they can impose sanctions. What we are seeing is the technical violation of probation, which means that there has not been a new law violation, but it can be a technical violation such as not going to school, missing a curfew, running away. And for girls, running away is often running away from the abuse in the home that is really the pathway for girls' involvement in the justice system. So probation is a critical opportunity to interrupt this cycle of incarcerating girls and young women. We can allow them to stay at home, to stay in their community, to stay connected to all of the support systems that help get them on the right track. Yet in the state of Florida, 1 out of 3 girls are incarcerated for a technical violation of probation. Next slide, please. When we look at girls and we look at what's happening to girls, we know that abuse and victimization is often the pathway that pushes girls into the juvenile justice system. Girls generally are high need and low risk. And when we look at the data from the Department of Juvenile Justice, at the time of incarceration, we can see that girls in almost every category show higher need than boys. Girls who are sent away have very high therapeutic needs, yet they are placed in systems where they are re-traumatized and re-victimized. The lack of community-based, girl-centered, trauma-informed services contributes to girls cycling in and out of the system. The availability of mental and behavioral health services and substance abuse treatment is woefully inadequate in our local communities, and this is one of the drivers that is pushing girls into locked facilities. It's not uncommon for a judge to send a girl to a lockup facility under the misguided notion that they will receive treatment for their complex mental health issues. Nearly 40% of girls at commitment have histories of sexual abuse or physical abuse. And this is much lower than what the research indicates. Some research shows as high as 92% of girls in the juvenile justice system have a history of sexual and physical abuse. More than half of the girls who are locked up have a diagnosed mental health problem that is related to trauma, violence, and exploitation. 10 years ago, girls who were victims of commercial sexual exploitation were likely to be detained in secure detention or incarcerated for offenses related to trafficking. The majority of these victims are female. Although Florida has passed very good laws, the Safe Harbor Act, which shows victims of trafficking as dependent, we are still seeing our most traumatized and exploited girls ending up in detention where they are further victimized and traumatized. Next slide. So in summary, the disparities that we see is that we know that girls are lower risk of recidivism and they are lower public safety risk. They're more likely to enter the system and be detained for minor offenses. And when they are detained, they're detained for longer periods of time. The technical probation violations will return them to detention or to a residential lockup without having committed another crime. And then while in the system, we see that girls are catching charges, which include things like assault on a law enforcement officer, for acting out in programs where we know that more often abuse is happening and the girls with trauma are being triggered. Next slide. Next slide, please. Our immediate call to action is to invest in community-based, girl-centered alternatives to incarceration that is aligned with the intense need that we know that girls have around trauma and mental health issues, to provide interventions that address intergenerational trauma versus investing in lockup facilities that further traumatize our most vulnerable girls, to reform probation and reduce or eliminate the overuse of the technical violations of probation, and to look at the Washington State model where we know that they have implemented an opportunity-based model of probation, to reduce the overuse of detention and the length of stays for girls, and to expand the Open Doors Outreach Network to address the needs of victims of trafficking. Next slide. Moving forward, in 2019, the Justice for Girls statewide reform movement will be launched by the Children's Campaign and the Dolores Barr-Weaver Policy Center. We will be actively creating the future by aligning leading-edge research, sophisticated techniques rooted in political science and expert communications to shift how we are responding to girls and young women impacted by the justice system. At the same time, the Policy Center and the Children's Campaign will be releasing the 10-year report card on the status of reform of girls in the state of Florida. So stay tuned for more information and opportunities to get involved in the Justice for Girls State of Florida movement. Thank you.
Thank you, Lawanda. That was excellent. Our next presenter is Alan Abramowitz, Statewide Director of the Florida Guardian Ad Litem's Office. It's an organization whose mission is to advocate for the best interests of abused, abandoned, and neglected children. Alan's very understated at times about his success. He's actually responsible for envisioning and passing a number of laws that have improved child welfare in Florida. He's truly an expert. Alan, what's happening with child welfare in Florida?
Thank you, Roy Miller. I appreciate it, and I appreciate the Children's Campaign with this visibility campaign and to ensure that the policymakers are aware of what's going on. And I appreciate the policymakers that are on the call. And when I talk about policymakers, it's not just legislators, but it's county commissioners, the Children's Services Council, Homeless Trust, city, everyone, and those that talk to policymakers, including the 35,000 alumni Guardian Ad Litem volunteers. So I appreciate this opportunity to talk, and most important, the fact that your organization is bipartisan. As most people know, every bill that DCF and the Guardian Ad Litem has done has never had a no vote, because we know that the policymakers care about children, and as long as they are aware of the issues, they will support the issues. So my thanks. Now, with a short time, I don't have the opportunity to talk too long, so I'm not going to focus on every topic, but try to hit 5 or 6. And if you look at the second slide, instead of having bullets on what we're talking about, I have a picture. And it shows the increase in out-of-home care through the years. And a picture tells this story, and it's easy to understand. We have major growth in children in out-of-home care, and the capacity of our workforce is overrun. If you look at a lot of the talk recently about adverse childhood experience and looking at trauma for children, we know the decisions that we make for children before we remove them from their parents may be the most important decision of their life. And so we need to treat it like that. But also, once they're in care, they may be having additional trauma. So it's not just whether you remove a child, it's what's happening in foster care. And what we have seen is that more and more kids have gone into care, and we have some significant challenges. Attorney General Butterworth said in 2007 at the Dependency Summit, "There's no margin of error when working with children. No one is allowed a bad day." And I want to emphasize that the day a decision is made on a child, whether to remove or not, is the most important day of that child's life. The next slide discusses the complexity of the issue. The federal government has just recently passed legislation about Family First, which shifts money to prevention and does not, in the future, won't be funding group homes with federal dollars. Clearly, they understand the issues of prevention and working with families that are motivated to do what's right for their children. We know we have limited money and unlimited children, and so we have to make the right policy decision, and the federal government is leading with that federal law. Florida has unique challenges because Florida had what's called the 4E waiver, where we were allowed to shift resources to front-end services starting back in 2007. So we've had an advantage early on, and it was a wise move, and we had significant reductions in out-of-home care between 2007 and 2010. We've seen innovation. For example, Dr. Nellius in Brevard County started Brevard Cares, where you didn't even have to call the hotline and have an investigation to get services, but anyone could get services through Brevard County, Brevard Cares, just by going there. And that was funded through community-based care. Florida has unique challenges, and they're making good decisions with regard to formula, the way they fund the formula, by including prevention and how many kids in out-of-home care is part of the formula. The turnover of caseworkers in the job that they do has become very challenging. We know from studies that every time a foster care worker leaves, we lose 6 months on permanency. And what we see is happening is as more children come in to foster care and there's more of a shift to those children, the children exiting foster care slows down. And currently we have a lot of children in foster care and turnover, and it needs to be addressed. And what we know right now, what's happening right now, is the opioid problem and other unique issues that increase the foster care. In a recent study, Troy Quace, FSU professor, talked about the association between the rate of removals of children from their homes and the opioid prescription rate in Florida between 2012 and 2015. And it has been a 32% increase in removals for parental neglect. Policymakers have to consider the opioid epidemic's effect on child welfare when determining the appropriate public health response. Improve access to treatment seems to be the best bet, but it certainly wouldn't solve all the problems. The most important thing is action needs to be taken. Recently, there was a federal legislation that gave a lot of money to the states to address opioids, but it is only the start. This is a serious problem and maybe the most serious problem in child welfare. If you go to the next slide for the decisions about youth, who makes the decision? We need to invest in ensuring the decisions made are the right decisions. And that means that we need to base it on evidence. We look at evidence, we look at research. Now, when we came up with community-based care years ago, they are laboratories of innovation. Challenges in Miami may not be the same challenges in Pensacola. And this gives us an opportunity for each community to address their issues. And if you look at it, this is the solution, evidence-based programming. For example, Healthy Families, probably the best prevention program that exists, arose out of a Kayla McKean child death back in about 2000. These families, we know, won't come into foster care, but they're very extremely high-risk families. That needs to be invested in. Right now, we have early childhood courts, which are using evidence-based problem-solving courts that ensures that the services are there for the parents, and we find that more families get reunified, and when they're reunified, less children come back into care, and the time in foster care is even shorter. We need to listen to the evidence and research, we need to invest, and we need to innovate. On the last slide, we talk about solutions. The capacity is something we need to address. Maybe we need to change the job so it's a workable job. We know that caseworkers do this work because they make a difference in the lives of children. Every study that the legislature has done has shown that. It isn't even the pay. We need to make sure that they have jobs that they can do and feel like they're making a difference. When their caseloads get too big, clearly they can't make a difference. We need to address turnover. We need to expand. We need judicial leadership. We need to focus on early childhood court, Healthy Families, and other prevention programs. Time is of the essence. A year is a long time in the life of a child, but most of all, we need to be accountable to children.
Thank you, Alan. We're honored today to have Scott McCoy, Senior Policy Counsel for the Southern Poverty Law Center, which is dedicated to protecting the civil rights and seeking justice for the most vulnerable members of society. Scott, what needs to change about children being tried as adults? We understand it's a very complex system.
Thanks, Roy, and the Children's Campaign for starting the visibility campaign and the opportunity to talk a bit about such an important issue for our kids. Florida prosecutes more children as adults than any other state in the country, and that is the issue that I want to talk to you about today. First slide, please. I want to first start by just a little bit of a background on how our system is set up, right? So in Florida, like many states, we have a juvenile justice system and we have an adult criminal justice system. And we have a juvenile justice system because we realize that children are not merely small adults. They are different. They are not well developed yet mentally. They don't have the same decision-making skills that adults do. They don't have the same life experiences to draw on. when assessing risk and making decisions and appreciating the consequences of the actions that they engage in. And so we've created a separate juvenile justice system for the purpose of holding them accountable when they make mistakes. Now, under Florida law, the law defines a child as a person under the age of 18 years old. And if that child commits a felony, then they are taken into the juvenile justice system where they are held accountable in front of a juvenile court judge in what's called a delinquency proceeding. So that proceeding does not find a child guilty or innocent. It finds whether or not they committed a delinquent act or not. And the sanctions that the juvenile court has at its disposal to hold children accountable are programs that are administered by the Department of Juvenile Justice. They can be community-based programs where the children receive services in their homes, in their communities, or depending upon the seriousness of the offense, there are different levels of residential programs where the kids are removed from home and they are separated from the community, but they are not necessarily, quote-unquote, incarcerated like an adult is in a jail or in a prison. Of course, the adult system we're all familiar with, and if you are held accountable in front of an adult court judge, you go to jail or you go to state prison. So that's how the system is set up and why. So next slide, please. So how are then children transferred from the juvenile system to the adult system? Well, there are really three ways: indictment, waiver, and direct file. And indictment is rarely used and is only used for the most serious offenses like capital offenses and crimes that have life sentences. Waiver is a whole other process that's not used because the third process of direct file exists. Let's talk about direct file a little bit more. Next slide, please. So what is direct file? And this is what you'll hear about the most. Well, under the direct file system, the state attorney or the prosecutor has unfettered power to unilaterally make a decision about whether or not a child will be tried as an adult or not. So in other words, the state attorney can pluck a child out of the juvenile justice system, drag them into the adult court system by him or herself. There is no involvement of a judge in that decision. Now, there are some age limits that apply to direct file. For 14 and 15-year-old kids, they can be direct filed for about a dozen felony offenses. And 16 and 17-year-old kids can be direct filed for any felony offense whatsoever. Now, the reason why direct file is what we're talking about instead of the other means of adult transfer is because 98% of all adult transfers from where kids go from the juvenile justice system to the adult system are through direct file. And that power was given to the state attorneys in the 90s at a time when we were experiencing high crime rates and there were some high-profile juvenile crimes that were taking place in Florida. Next slide, please. So what are the statistics and what's going on? Well, like I said, Florida prosecutes more children as adults than any other state. Since 2009, nearly 14,000 children have been prosecuted as adults in Florida. Now, in the most recent statistics that are available, over 1,100 children were prosecuted as adults, and many hundreds more were threatened with being prosecuted as adults. Now, when we look at the crimes that children are committing to be sent to the adult court, we find that most of children tried as adults are actually charged with nonviolent offenses, so like property crimes or drug possession offenses, etc. Now, fortunately, the number of children that are being prosecuted as adults has been going down, but that is likely because we are seeing youth crime at a historic all-time low. Next slide, please. So why is that a bad thing, you may be asking? Well, this is how direct file fails our children. First, direct file children have to be held in the adult jail pending trial. So, if a child is prosecuted as an adult, they have to be held in the adult county jail. That's bad because children are often held in solitary confinement in the adult jail, and also jails are not well equipped to deal with children and to care for them. They're built to deal with adults. And these kids who are still innocent until proven guilty have a right under the federal and state laws to receive education even while they're in the adult jail, and the adult jails just simply are not good at doing that. Second, children of color are way more likely to be prosecuted as adults than their white peers. So we have huge racial disparities in the system as well. Next slide, please. Children, and third, and if you're interested in public safety, which we all should be, of course, we find that children prosecuted as adults are actually more likely to reoffend than their peers who are held accountable in the juvenile justice system. So you get a worse public safety outcome by transferring a child and prosecuting them as a Fourth, according to a JMI study, that's the James Madison Institute, if you look at the kids that were direct filed, 70% of those kids were received only adult probation. They didn't actually receive a prison sentence based on the crime that they were tried as an adult for. Which begs the question, why was it necessary for those kids to be tried as an adult in the first place? Adult probation is really, really hard for kids to comply with, and as a result, many of the kids that are currently in prison are serving sentences not because of the crime that they committed, but because of a violation of their probation that they committed, like missing a curfew. And then finally, children prosecuted as adults receive a felony conviction. And what that means is that they have a felony on their record for the rest of their lives, and it makes it harder for them to get housing, employment, education, and things of that nature. So we're burdening them from the very early age with something that stays with them for the rest of their lives. Next slide, please. So what are we going to do about this? What should we do about this? Well, one of the things that we think we should do, first and foremost, is involve a judge in the process. And we propose creating what we call a fitness hearing, so that once a child is transferred to the adult system by the state attorney, he or she should be able to go to a judge and say, wait a minute, please consider my specific circumstances and understand that I would be better held accountable in the juvenile justice system and send me back. So that's one. Two, we would like the judge to have the flexibility to determine where a child should be housed pending trial. So not automatically in the adult jail, maybe at home, or maybe in a juvenile justice facility that would be more appropriate as that child waits for a determination of his sentence. There are a couple of more things there too that have to do with age limits and making sure that we don't prosecute as many young kids, and so that's important reform too. Next slide, please. So finally, I just want to show you a little bit about what the public thinks. So according to recent polling, 70% of Floridians believe that a judge should be making the decision, not a prosecutor, about whether to prosecute a child as an adult. So this is a wildly popular idea in Florida. And then according to that same poll, 74% of Floridians believe that children charged with crimes should stay in the juvenile justice system and not be transferred to the adult criminal justice system. So we're not talking about not holding children accountable when they make a mistake. We're talking about what's the appropriate way to hold them accountable. Next slide. So we have a coalition that's fighting for reform. It's called the No Place for a Child Coalition. There's some information there if you'd like to learn more about it. And then finally, I'll just say, we really do believe that our children deserve better, and the way that the system is currently constructed and set up does not meet the best interests of the child, and we have some simple reforms that could change that, and we hope that this will give you an insight into that system and perhaps prompt you to support some of the changes that we think would make our system even better for our kids.
Thank you, Scott. And I want to thank all the presenters for their excellent remarks. We're now moving to the question and answer time. I have several that have already been submitted. I want to remind everybody that you can use your chat feature to pose questions, and I'll get to as many as I can. Scott, since you went last and we have a question, I'll just go ahead and go to you first before I pose the questions to Alan and to LaWanda. A question was asked that numbers of direct file seem to be going down, and some are making the argument that law changes aren't necessary because there's been more circumspection. But I know you have some definite thoughts about why changing current law is important. Can you share those, please?
Sure, happy to. And I think the good news—
And get a little closer to your mic.
Sure.
You're fading out a little bit. So.
Is that better, Roy?
No, it's not.
Weird. I don't know what's going on. Okay. Well, I'll try to speak louder.
There you go.
Okay. It's a good question. The good news is that direct violence numbers have been going down over time, and I think that there are many things at play there. One of the largest is that our youth crime rate has dropped significantly over the last period of time. So there are actually less kids committing crimes that are eligible for direct violence. We've also had some state attorneys, new state attorneys that have been elected. In particular, Melissa Nelson in Duval County, Andrew Warren in Hillsborough County, Aramis Ayala in Orange County and those areas. And they have understood that maybe the process of direct violence has not been used the best way possible. And that's good. But the difficulty we have is that we don't think that the fate of our kids should be dependent upon a single state attorney that might get elected or not be elected the next time. We think that there is a better process for our kids. And that process still involves the state attorneys, but we also think that it would be better for the decision about direct violence to be made by a neutral judge, and that both sides can come in and present their evidence and make the case about where the child should be best held accountable. Unfortunately, that process doesn't happen right now. And so while we may be experiencing lower numbers now, and we may have some state attorneys that are starting to review their policies and do things differently, that unfortunately is not permanent, and it's fleeting. And we think that if we want to make the system better for everyone, I mean, that also begs the question, Roy, you mentioned earlier, of justice by geography. If you live in a jurisdiction with a state attorney that gets it, and the next kid doesn't, then we have unequal justice across the state, because the same kid doing the same conduct may be direct violence and the other one won't be. So if we had some consistency, that would be helpful, and we just think that to make the reforms permanent, we should involve a judge and create a process that then is reviewable and more permanent.
Thanks, Scott. I think those are really excellent points. LaWanda, there's like 3 questions coming your way. I don't think they're too complicated, so I'm going to ask you all 3 of them. So one person commented on, in fact, a couple people did, the fascinating data that you presented, and they'd like to know the source. Another person asked about services to differing abilities. They're wondering if there's been any progress in serving girls with differing abilities. There's been a history of them ending up in programs that are really not designed to meet their needs. And then the third question was about the distinction between the needs of girls and boys, and how do you measure, or how do you address issues of determining, neediness? What's the real critical factors that may distinguish girls from boys? So those are 3 different questions.
Roy, can you share the second one again? You went out. You faded out.
Yes, it was about differing abilities. A person is asking about the status of services to girls with differing abilities.
Okay.
That they know there's been big gaps in services and inclusion of girls in programs, of differing ability girls in programs that don't meet their needs. They're wondering about the status of that.
Great. So the first question regarding the data, that actually comes from the delinquency profiles, the Florida Department of Juvenile Justice delinquency profiles. And if anyone is interested in the longer studies, you can go on our website at www.seethegirl.org, and we have research papers on the trends of girls in the justice system. But that data actually comes from the Department of Juvenile Justice profiles. The second question regarding girls with differing abilities, that continues to be a major problem in the state of Florida. What we see is that girls who have developmental delays with differing abilities ending up in lockup facilities, and there are no specialized services for girls and young women in our state. And the providers, where these girls are ending up in the lockup, the providers are also acknowledging that they are ill-equipped to really meet the multiplicity of needs of this population. And we don't have good research data on the percentage of girls who are locked up who have developmental delays or disabilities, and that is an area that needs urgent attention in the state of Florida. The question regarding the disparities or the needs of girls, so there is I want to be clear on the difference between needs and neediness. We are not defining the needs of girls as neediness. What we are really talking about is girls are being pushed into the juvenile justice system. And if you look at the PAC data, which is the data at disposition from the Department of Juvenile Justice, you can see in almost every category of need, from abuse to being placed out of homes, to neglect, to sexual abuse history, trauma, witnessing violence, diagnosed mental health problems, self-mutilation history, suicide attempts, suicide ideation. Girls have higher percentages of experiencing these lived experiences, which increases their need, and because of the lack of appropriate girl-centered services in the community, we are seeing girls pushed into lockup facilities because their needs are not being addressed. And so the very survival strategies that girls use to try to survive in the communities where they are living and in the situations that they are being forced into are outside of what we would see as gender norms in our community or in our state. So as a result, that girls are punished because they are behaving outside of what are acceptable norms for girls. And so the failure is not on the girls. The failure is the lack of community-based services and interventions to address what is driving their behavior. And we know that for girls, the pathway into the justice system is paved by prior abuse, victimization, and exploitation.
Thank you. Alan, there's a couple of questions on some themes here. You mentioned turnover of different workers in the child welfare system, case managers, investigators, etc. And it's been a problem for years. And people are asking, are there any cutting-edge human resources solutions that are making an impact? And another recurring question I'm receiving is the capacity of foster care. You showed very deep spike in numbers of children removed from home. Is the trend of foster home recruitment steady, going up, going down? What's happening out there?
Thanks. Great questions, and they hit the nail right on the head. Every month, the first data I look at when I go online and get DCF's data, because they issue a report every month, I look at how many children that are removed are placed outside of the county they were removed from. And what you find is 37% of the children are not even placed in the county they were removed from. There's one community-based care agency that's as high as 80%. And when the kids are not in the community, the caseworkers, and remember they're over capacity because the case numbers are so large, they don't feel like they're making a difference. They're not seeing their children because another case manager from another place is seeing their child. So you don't get that the reason they do it because they're passionate about children, they care about children. And one of the issues is we don't have enough foster homes. We have about somewhere between 5,000 and 6,000, but that's not the biggest issue. We haven't recruited enough foster homes to take older children. Right now, 32% of the children, 13 to 17, are in group homes, and 9% of all children are in group homes. Well, if you don't feel like you're making a difference as a case manager, you don't stay in the job. We need to invest in foster care significantly. We need to support foster parents. We need to ensure that the regulations aren't so onerous that people don't want to do it because they don't feel like they're making a difference, that it's more bureaucratic than caring for children. The foster parents need to be partners. They need to feel like they're making a difference too, because that's why they foster. So I would say that big investment, caseloads cannot be 20, 30, 40, 50. That will make a difference. If they can work on their cases, they will get the children permanency sooner, and they're more likely to get the child timely reunified, and if they can't get reunified, the parents' rights will be terminated. So I think there are solutions. I think we need to make a better effort at recruiting and supporting our foster parents to be able to really make a difference. And you know, the foster parents really want to help. I mean, they are advocates also. I know we have guardian ad litems out there on all these cases, but the person around the child all the time is the caregiver. So we need to really start listening to them. I know in the statute they're participants, they get to be heard, but we really need to listen to them, and we really need to make their experience good, because the best way to recruit foster parents is by word of mouth. And if they don't feel appreciated, we're not going to expand foster kids. So but I would say that capacity is a big issue. There are ways to address it. We need to rework the job and invest a lot of money in it so the caseloads are extremely small so they can make a difference. And that way the children will be able to come back to the communities. And I don't know how you get reunification when a child's so far away from their parent when it comes to visitation, sibling visitation. So that would be my main point, is there are ways to address it, and the legislature's looked at it, and they've done reports, and we know that the caseloads have to be small.
Thanks, Alan. There's another question for you and one for LaWanda, but first there's a question for Scott. Scott, we're being asked, how do we educate those who make the decisions about putting a child in secure detention? How do we educate them to look at other options?
That's a great question too, and hopefully you guys can hear me a little bit better than before. So, you know, I think one of the best things to do is ask our legislators to actually go and visit the secure detention facilities, so one, they can see what it's like. A lot of those places are not really, you know, fantastic environments. So it would be good for them to have firsthand experience with that. Second, you know, I think we need to have a conversation about our secure detention facilities, our residential facilities, and really ask ourselves whether or not we're investing our money wisely for our kids by using that model. There are other states that are approaching juvenile justice in a much different way and using much more community-based, home-based interventions and supervisions that are having better results than we are with our secure detention and our residential programs. So, you know, we have to ask ourselves, we're spending over the last how many years, you know, millions and millions and millions, hundreds of millions of dollars, and our recidivism rate for our Department of Juvenile Justice is still something like 40%. That's terrible. That's a bad investment, return on investment. It's not good for our taxpayers. It's not good for our kids. And I think if we make sure that we talk to our legislators about this and really get them into, you know, the system and to see it, and to also look and see what others, our sister states, are doing and how they may be doing it better, I think those are compelling and maybe the best way to educate our legislators about the juvenile justice system and ways that we can do it better.
Thank you. Alan, the question that came in, I'll give this one to you before I ask the one that came in for LaWanda. Prior to where your chart started, person's asking, wasn't there a higher out-of-home rate that was in the 20,000s area, and then it went down to the 17,000 area, and now it's spiking back up? What's the history there? How were the numbers decreased prior to that low point, and now there's a spike? Was there anything to be learned on how to deal with the current issue from the reductions in the past?
That's a great question. Yes, you are correct. And I remember when I started off, I was with Department of Children and Families in 2000, and there were a lot of lawsuits at the time, and the numbers were skyrocketing. And it was just so many kids in care, a lot of kids in locked residential treatment centers, not because they shouldn't have been in a less restrictive environment, but because there were none. And back then the state had it. Under Governor Childs, who started privatization in the Hillsborough area, and later Governor Bush, who later passed the statute on community-based care, I think what you saw is two things happen in 2007. You saw a combination of privatization and what is called the 4E waiver, where instead of the federal government only funding children in foster care, it created the flexibility to shift resources to prevention and intervention, and the money would follow the child, whether they stayed home or whether they came into care. A combination of privatization and at the same time the 4E waiver made a huge difference, because as we created these laboratories of innovation in the private sector, it didn't take long to realize that the least restrictive alternative for a child that was successful was also more cost efficient. For example, if you could keep a family together, like with Healthy Families, an evidence-based program, you're saving so much money. Or if that can't work and they go with a relative, that was paid through TANF or another funding stream, so it wasn't costing the private entities dollars except for case management. And foster homes were a lot cheaper than group homes, and group homes were a lot cheaper than residential treatment. So you had a natural effect through privatization where the best thing would happen for the child, because if they went to too low a restrictiveness area, the outcome would be even worse, and they would end up failing their performance indicators. And that was going good from 2007 to 2000, probably 2010, 11. And I think we need to get back to the laboratories of innovation, and we're starting to see it. I've heard from one person who just got family finders in the Hillsborough area because a lot of the older kids having placement problems, and they found 8 relatives for 8 children. So you're starting to hear these stories. I think we need to go back to thinking that we need to really focus on innovative practices. And the idea that you can't control the number of kids coming into care is inaccurate. Although the individual caseworkers shouldn't be focusing their issues on how to get their numbers down, top management knows that the more resources that you have for front-end services is the less children will come into care. And, you know, I've said it before, the opioid issue has basically taken over. And that may be the hidden thing that's really caused the great increases. Think of this, 129% increase over a 3-year period from 2012 to 15. And it continues. Now, this last year, we actually have in the last year about 900 less children in out-of-home care. So they're trying to get a grasp on it, and we need our community-based care agencies to focus on innovation, science, evidence-based programs. And I know that we can get back to where we were in 2008 and continue to keep these families together, because most of these families really care about their children, they love their children, and they want a good quality of life for their children. And if those that are motivated to get help, we need to make sure it's there. Not because of them, but because of the children. It's in their best interest. Thank you.
Thanks, Alan.